audience. This lecture is out of our normal routine. Every summer, the Supreme Court makes many decisions impacting healthcare, which impacts you and the care that we all provide. We plan on hosting this particular lecture about law and medicine every August now to bring you an update as to what's happening nationally in the legal realm. We know that things also happen at the state level, and IU Health Risk Retention is offering a lecture actually right now covering the state's updates. We will work better next year to coordinate to make sure that they don't happen at the same time in the same day. But both of our lectures for this, our lecture and their lecture, are being recorded, and we will have both of those links up on our website as soon as we can. So let's just get rid of a few preliminaries. We know that COVID continues to impact our world, and we miss being in person. As long as we can, we will try to stay in person with the fact that we can only have 40 in our audience. But please know that this can change at any time, and we will keep everyone as informed as we can. So when you register, you can say if you want to be in person or do it virtual. And if you want to be in person, once we hit 40, then you will be forced to go virtual. And while we have all become masters of Zoom, we appreciate your understanding for any technical issues, especially as we move into the live setting. This webinar is being recorded, like I said, and it will be available on our website, fairbankcenter.org, within the next week. You will receive a link for CE evaluations tomorrow at the email address that when you register for this webinar. You must complete that evaluation to receive continuing education credit. Questions and answers can still be asked if you post them in the Q&A box, but we're not going to respond to them until the very end of the presentation. And for those of you that are here in person, you will have the opportunity to ask questions as well. And Professor Orenstein has no relevant financial conflicts of interest to disclose. Okay, with all of that out of the way, it is so exciting for us to welcome Dan Orenstein, who is a visiting assistant professor of law at Indiana University McKinney School of Law. And he also recently served as the interim director of the Hall Center for Law and Health. His research focuses on health and public law with a current concentration on cannabis law and policy and its relationship to tobacco and alcohol control. He has also published on a variety of other health law topics, including vaccination, organ donation, and emergency preparedness. Prior to coming to IU McKinney, he completed a postdoc fellowship at the University of California, San Francisco Center for Tobacco Control Research and Education. He also previously served as deputy director of the Network for Public Health Law Western Region, where he provided technical assistance, resources, and training on public health legal issues to public health officials, practitioners, advocates, attorneys, and others. Prior to law school, he worked in the organ and tissue transplantation field in his hometown of Phoenix, Arizona. He earned his JD summa cum laude from the Arizona State University's Andra Day O'Connor College of Law, and his MPH in health policy from the Harvard T.H. Chan School of Public Health, and his BA with honors summa cum laude from the University of Arizona. I know already from just interacting with him and watching him interact with people here in the audience that he must be a popular professor and a really wonderful professor, because everyone who was here who has greeted him warmly instead of hiding in the back. So we welcome you and thank you for coming and sharing with us.
Thank you very much. So thank you to the folks who are here. I am going to remove my mask. I was told this will be fine, as I assure the audience, quite far from everyone who is here in person. I'm also quite far from all of you, unfortunately, who are watching from home, but I know you're out there. Hi, Mom. Hi, Dad. Oh, they think I'm kidding. I'm not kidding. They're definitely watching. So you got my introduction. I do have a couple of quick caveats because it just wouldn't be a presentation by a lawyer or a law professor without a couple more of those. I am a lawyer by training. I am barred in the state of Arizona, but I am not your lawyer, any of you. So none of this is legal advice and shouldn't be taken as such. The opinions are solely my own. They do not represent Indiana University, IU McKinney, the Hall Center, or anyone else. And I do not have any relevant conflicts of interest to disclose today. So as you heard, this is going to be a little bit different from what you're used to in this series, but I want to give you a little roadmap of what I'm going to talk about today. So I know that for the most part, people here and watching at home are not lawyers. They haven't had any legal training. So I'm going to give a little bit of a primer on the US court system, just enough to make sure that we know where we are in this. And then I'm going to talk mostly about important Supreme Court health law cases from this past term. You'll see that abbreviation pop up, Supreme Court of the United States. I'll also talk about some upcoming cases that I think you'll want to keep an eye on if you're in this field, and then talk just briefly about a couple of noteworthy cases making their way up from other courts in the country. So, in a nutshell, we have a two-part system for courts in this country. State courts, on the one hand, they deal with state law, but that is really most things, most cases, most law, everything from your garden variety, civil case, a tort claim, a med mal case, whatever it might be. Any violations of state law, this goes up through the state system. Trial courts, appellate courts, and a state Supreme Court, but they might call them other things. New York in particular has really strange names for all of them, but it's all basically the same system. These trial courts at the bottom, they're the ones that take evidence, they take testimony, so on and so forth. Two levels of appeal above that. If you think that the court that heard your case is wrong on the law, you can appeal it up to an appellate court. If you think that appellate court is wrong, you can appeal it up to the state Supreme Court. And what those courts do is review the record, figure out, was this done correctly? They don't take new evidence, they don't hear new testimony. They're just reviewing the case as it was done. Their decisions are binding on those courts below. So the appellate courts, what they say goes for the trial courts. State Supreme Court, what they say goes for all the courts below them. Then we have the federal court system. This is separate. It is fairly distinct. They're dealing, as you might expect from the name there, with federal law. They're across all the states, 94 district courts, 13 circuit courts of appeal. So you'll have heard these, the Ninth Circuit, the Second Circuit, the Fifth Circuit. Indiana's in the Seventh Circuit. These are all geographic. And then the US Supreme Court. Same deal over here. You can appeal up from the district court to a court of appeals. You can appeal up from the Court of Appeals to the Supreme Court. Why is that one a different color? Because the Supreme Court doesn't have to listen. They get to choose if they're going to take the case. There's three ways you get there. This is the most direct. You have a case in federal court, appeal to the circuit court, appeal to the Supreme Court, and they decide to take it on appellate review. Great. You can also, maybe, appeal over from your state Supreme Court if you've made it up through this state system, but you think they did something wrong as a matter of federal law. Usually this is going to be something to do with the US Constitution. So you could get there, but the court's not going to hear this if it has something just to do with state law. Indiana Supreme Court, they're the final say on issues of Indiana law. But if they do something wrong in terms of federal law, US Supreme Court can step in. There is one other way you could get to the US Supreme Court. Original jurisdiction, this really doesn't happen all that often. Specific types of cases that are spelled out in the Constitution. State wants to sue another state, you can go straight to the Supreme Court. Case involving ambassadors, straight to the Supreme Court. Not a lot. This is the current US Supreme Court. So I was asked to give a little bit of explanation and background here on who's on the court right now and how that's sort of changed recently. So there are 9. It's been 9 for a while now, since shortly after the Civil War. Before that, it was anywhere from 5 to 10. Chief Justice John Roberts, appointed in 2005. He is the head of the court. Everyone after that is in order of seniority, both in this picture and when they sit in hearings. When they sit as the court, they sit in this order. Clarence Thomas, Stephen Breyer, Samuel Alito, Sonia Sotomayor, Elena Kagan, Neil Gorsuch, Brett Kavanaugh, and our newest justice, Amy Coney Barrett. So as you'll note from who appointed these folks, this is presidential appointments with advice and consent of the Senate. That's been subject of a lot of controversy lately in terms of that process, but it's fairly unpredictable. Often these Supreme Court seats become available because a justice has died. They have lifetime tenure. In fact, there are only 3 living retired Supreme Court justices: Sandra Day O'Connor, David Souter, and Anthony Kennedy. That's it. There's also currently 6, maybe 7, depending on how you count, Catholic justices and 2 Jewish justices of these 9. That's really unusual historically. Up until fairly recent history, there were no Catholic justices and no Jewish justices. So this is really odd and worth thinking about when we start to talk about some of the cases of religious liberty today. It's been a big year and a half going on 2. In health, in public health, and in health law, no surprise, follows along. So these are the types of cases I want to talk about today. We've got all the big heavy hitters: the Affordable Care Act, abortion, COVID-19, CDC authority, Medicaid, vaccination, and everybody's favorite law to hate, ERISA. I promise not to talk about that for long. So let's get started with the ACA. I'm giving you the too long didn't read version off the bat. ACA is still standing. That's the end result of what was a pretty confusing case, honestly. California v. Texas, this was our big ACA case of this year. We've had the ACA now for more than a decade. It's been almost constantly in the courts. This is the 3rd time the ACA has been to the US Supreme Court in that time. That's not very common. The most important thing here, I have to tell you about another case to tell you about this one, or it makes absolutely no sense. The first time the ACA was challenged in court, NFIB v. Sebelius, National Federation of Independent Businesses, challenged the individual mandate. This was the part of the ACA that said, if you don't have some form of health insurance coverage, you have to pay a tax penalty, unless you meet one of the few exemptions. Supreme Court, somewhat surprisingly in that case, federal government said, we are doing this under our Commerce Clause power. Congress has enumerated powers. One of them is to regulate interstate commerce. This is a really important power that Congress has. Supreme Court said, that doesn't really work here. What you're mandating is to engage in commerce. But it's a tax penalty. So it is valid under another power Congress has, which is the power to levy taxes. It's important because the federal government only has the powers the Constitution gives them. Anything other than that, any other government power belongs to the states or to the people. That's in the 10th Amendment. So what we had here was the court saying, okay, this is a valid tax, but you can't do this on your Commerce Clause power. Fine. That's all well and good for a few years. 2017, however, we have a political change, Republican majority and a Republican president for the first time since the ACA had passed. And in 2017, Congress didn't have the votes to repeal the ACA, very famously John McCain's thumbs down on the Senate floor, but they did have the votes to make the tax penalty $0. So it's still on the books, you still have to have insurance, but if you fail to do so, the penalty is 0. So the question was, is that still a tax? Is a $0 tax a tax? If it's not a tax, does that mean it's not valid now? Because it was only the taxing power that made this constitutionally acceptable. And if the individual mandate is invalid, is the entire ACA invalid? These were the big thorny questions that the court was going to deal with. Justice Alito, in a dissenting opinion in this case, said it was the 3rd part of their epic ACA trilogy. It is a trilogy, but it's a little more Godfather 3, in my opinion. The last one is sort of unnecessary and really unsatisfying. And now I told everyone in person that they had to laugh really hard at the bad jokes. For the folks at home, obviously, I didn't explain this well enough. That's one of the bad jokes. So I say it's disappointing, it's unsatisfying because they didn't answer any of those questions. All those big questions, is it still a tax? Is it invalid? Can it be severed? Don't know. The answer was nobody gets to bring this case. Nobody has what's called standing. This is just a constitutional doctrine. This is why this case is a little bit confusing. The answer here is, remember those systems, state court, federal court. This is all over our constitutional structure. We have a federalist system. We have separate federal and state everything. Federal courts, per the Constitution, hear cases and controversies. They don't give advisory opinions. And so to bring a case, you have to have standing to bring it. And what that mostly boils down to is someone has to actually be injured. Not physically injured, but some type of injury, something the court can fix if you win your case. And here, there were individuals and there were states challenging this. The individuals said, well, we have to pay for insurance coverage. That's an injury, an economic injury. From this law, we say is invalid. Court said, well, the penalty is $0. It's unenforceable. That's not an injury. You paid for insurance coverage, but nobody really forced you to. A couple of states also challenged this. They said, well, this increases the costs of our state-run insurance plans, like Medicaid, because more people sign up. Same problem. A $0 mandate is unenforceable, so that doesn't actually increase enrollment. Not really a satisfying end to this, but the impact is what's important. Third time the court has heard the ACA, every time it has come out still standing. That means the ACA's framework continues, all of it. Marketplaces, where you can buy insurance if you don't have employer coverage, Medicaid expansion in the states that have adopted it, insurer rules on pre-existing conditions, all of those other bits and pieces that came along with this really big change in the law 10 years ago. All of that is still in place. Now, you didn't think you were getting out of this without talking about COVID, right? Or without seeing this really familiar graphic. It's impossible. It's 2021, you have to have this. I don't care what I'm talking about, this graphic is in there. We had a lot of cases on COVID-19 restrictions hit the Supreme Court this session. These are the three big ones: Roman Catholic Diocese, South Bay, and Tandon. We'll go through each of them in a little bit of detail, but before I do, I have to explain this really nefariously named thing called the Shadow Docket for this to make any sense. So all those three ways that you can get to the Supreme Court, the court ends up hearing about 60 or 70 cases in a given term. But that's just on the merits. For those cases, there'll be extensive briefings, dozens and dozens of pages. There'll be oral arguments for hours. They'll be answered with really well-researched opinions, hundreds of pages sometimes. They get a really thorough vetting. But on top of that, the court actually has to respond to thousands of other issues, usually with short summary decisions. Most of these are just simple procedural things. We want an extension on our deadline to file the brief. We want to reschedule the oral arguments. We want to, make these tiny procedural changes, unimportant in the grand scheme of things. But sometimes we get some really important questions that come up under urgent or emergency circumstances. They have to be answered quickly. There's no time to go through the full process. So we don't get that extensive briefing. We don't get full oral arguments. We don't get all of these things that usually go towards making a really clear, well-reasoned, well-researched opinion. So sometimes it's not very clear what the court is doing or why. One of the main ways this has come up, and it's come up in all of these cases for COVID, is injunctions. Cases take a long time to play out. That process of marching up that triangle through the courts, that can take years. But if you're challenging and saying this law is unconstitutional, you can make an argument to the court to say, this shouldn't be enforced against me while I'm making my way through the judicial system. That would be wrong because it is unconstitutional. If the court agrees with you, they issue an injunction. It doesn't finish the case, it doesn't answer all the questions, but it does preserve the status quo. So this new law that you say is unconstitutional won't be enforced against you while you're making your way to the court. That's not the way it's normally supposed to work. This is an extraordinary remedy. So you have to actually be very convincing to win one of these challenges. You have to convince the court that when you get there, you're probably going to win. You're likely to succeed on the merits. And in the meantime, if the court allows enforcement, you're going to be irreparably harmed, something that can't be taken back. And the balance of interests, including the public interest, favors putting a stop to things. And that's what we get in these three COVID cases. They're asking for these preliminary injunctions to stop enforcement. We've got a case from New York, two from California. So Roman Catholic Diocese is probably the most important as it turns out, although initially it doesn't seem that way. New York's governor, now former governor, but we don't have time to get into that problem. He issues an executive order, identifies clusters of cases, and then says, around these, we're going to draw sort of concentric circles, more or less. Red zone, orange zone, yellow zone. And we're going to cap worship attendance and a few other things, but we're going to cap worship attendance here. If you're in the yellow zone, 50% capacity, orange zone, 25 people, red zone, 10 people. Doesn't matter if your church or synagogue or mosques hold 100, 1,000, 10 people. Problem here was that there were other rules for other types of entities in the same zones. We all got familiar with the idea of essential businesses this last year and a half, right? Grocery stores, home repair shops, depending on where you work, could be a lot of other things as well. Entities that were deemed essential were allowed to stay open in those same zones with a different set of rules. And this was challenged by a Catholic diocese and 2 Orthodox Jewish synagogues. They said, you're violating our First Amendment right to free exercise of religion. You're preventing us from attending worship services here. The way this works on the legal side is this idea of strict scrutiny. If you are, as the government, discriminating against religion, then that triggers strict scrutiny. That means the government has to show what we're doing is narrowly tailored to further a compelling government interest. That is a very demanding legal standard. It's often called strict in theory and fatal in fact. If this applies, the government usually loses because it's very hard to meet that standard. You also have to show that you're doing it in the least restrictive way possible. Very, very challenging to meet. The problem here is that explicit distinguishing between the religious and the secular entities. The executive order explicitly says, essential businesses, these rules. Worship services, these other rules. Distinguishing is a form of discrimination. So this is where we get into trouble for New York here. It didn't help that New York's rules were stricter than other states, and that they didn't distinguish between those small and large venues. Again, it was 10 people in the red zone, whether it was a room this size or a room the size of the hospital. So ultimately, the court does say this goes too far. This is unconstitutional. The government hasn't met that burden. They haven't showed that this was narrowly tailored to further a compelling interest. Now, one interesting piece of this is that the Chief Justice is in the dissent. So it's 5-4 on the court here. As the court has changed, we've had, of course, as I showed you, 3 appointments within Donald Trump's prior term as president. That has shifted the balance of the court ideologically a bit, particularly the appointment of Amy Coney Barrett, who replaced Ruth Bader Ginsburg. So the Chief Justice now is a little bit of a swing vote there, but there are 5 fairly conservative votes to his right. So he ends up in the dissent here, and that can be a powerful thing. Having the Chief Justice as a swing vote, they command a lot of respect. They can shift the framing of a lot of things, but he didn't quite carry the day here. Even though he pointed out he didn't even want to hear this case because New York, by the time this had gotten to the Supreme Court, had already changed the rules. So why are we doing this? Why bother? Well, the other 5 justices made a very good point with that, which is this is a rapidly evolving issue. The governor could easily do it again, anytime. Identify a new cluster, new red zone. More important here probably is this issue that the other dissenters pointed out, the other 3, which is the problem here is about figuring out what is a comparable type of entity. Those essential businesses were treated differently than religious worship services. That may be okay if they're not similar, because that discrimination only applies if you're discriminating between factually similar types of entities. Is a church like a grocery store? Dissent says no. And they said more comparable things would be a lecture, a concert, sports, theaters. Those types of things had to close entirely if they were in the red zone. Religious entities didn't. And indoor, close proximity, singing and speaking, long duration, those are the most relevant factors in the pandemic. This is different than a grocery store. But they don't win this case here. It looks like we get a new rule out of this case. which is religious entities and religion generally must receive kind of most favored status. They have to get the best possible treatment or strict scrutiny applies, remembering that that means the government's probably going to lose. I want to watch that play out a little bit. So this South Bay case, we shift coast now over to California. California said, gonna have some tiers of restrictions. In tier 1, no services, no religious services of any kind. Below that, we're gonna have a capacity limitation, 25% or maximum 100 people. Also, no singing, no chanting, because these are the types of things that we're concerned about in close proximity in an indoor environment. Again, several justices view that as singling out religion, and I mean, it does, right? That's religious services explicit in the law. It does single it out for different treatment. The question is it justified? But the court's badly split here. They do ultimately allow the percent capacity and the singing and chanting restrictions. But yes, California can limit you to 25% capacity and say no singing or chanting in an indoor church service. But that tier 1 restriction, no services of any kind, that's out, unconstitutional. That's the only outcome that agreed to by 5 justices here. 2 of them would have blocked all the restrictions. 3 of them would have allowed all the restrictions. 1 of them would have blocked them all temporarily to give California a chance to prove its case better. 2 of them said the singing restriction's okay, but the capacity restrictions are not. This was messy. So what happens when it's that badly split, when it's that messy, is the narrowest thing that 5 agree to, a majority. And that's what we got here. Total prohibition's out, other 2 are okay. And that's the Chief Justice's concurrence that ends up carrying the day there. He's in the middle again. And his reasoning is important. He said, we are supposed to be deferential, the court is supposed to be deferential to public health determinations. Court is not composed of scientists or epidemiologists or experts in anything other than law. But that total prohibition doesn't really reflect expertise or discretion. It's too broad, it's a blunt instrument. So we don't have to defer to something like that. Singing and chanting, that's more specific. Capacity limitation, that's a little bit more nuanced. That's expertise. A flat prohibition, no deal. California's argument here is important. They said the religious services are different. Church isn't like a grocery store. You got a lot of people from a different household in close physical proximity for extended periods of time, singing and chanting. Decent argument. 3 justices said, that's missing a couple of pieces. Not every religious service has all of those things. Things that aren't religious services, secular activities, some of them do have those. You might get a lot of people in close proximity for extended periods, singing along, concert, why not? But most importantly, missing the less restrictive options here. So why was that flat prohibition on all services unconstitutional? Because it's not narrowly tailored. It's not the least restrictive way. You could put a capacity limitation. You could say, maybe, no singing or chanting, but have that be applicable to everything, whether you're on a Hollywood set, on a stage, in a concert, in a religious service. There's other ways to go about this. On the other side, though, again, this is a badly fractured court here. Another 3 justices who said, we're not scientists. It's not our job and it's not our expertise to opine on those things. We have to defer to the experts. And other protected First Amendment activities. The First Amendment isn't just religious exercise. So let's compare apples to apples. Political meetings, lectures, those are protected First Amendment activities too. But they were completely prohibited. They got similar treatment as the religious services. So the state hasn't treated religion differently if you choose the right comparison. That's where the fight's going to be in the future. What is a comparable activity. And we'll see that play out here in the last case very briefly. Still in California, prohibition limiting gatherings to a maximum of 3 households. This is challenged as it applied to at-home Bible study or prayer meetings. It's a really short opinion this time, but it's really important because it clarifies the new rule. The court sets out, it says, in Roman Catholic dioceses, we set out this rule. It's really helpful when the court does that. Makes all the lawyers smile because it's a lot less work. They said government rules are going to trigger that strict scrutiny standard whenever they treat any comparable secular activity more favorably than religious exercise. Any, I have highlighted, it is italicized, this is a direct quote. Any comparable secular activity. So it does get kind of most favored nation status here. The state has the burden to explain why less restrictive options don't work. So here, one of the questions was, why couldn't you say, well, if you're doing it at home, you need to wear masks, you need to have been tested, things of that sort that applied elsewhere. There are reasons it might not work, practically speaking, and the dissenters point that out. But the problem is California needs to explain it. They can't assume that those things won't work. They have to explain why not. So what this is really going to be, this new rule, and it is a new rule, whether the court thinks so or not, the rule previously had been if you have something that is neutral and generally applicable, applies across the board, that doesn't trigger strict scrutiny. But here we say any comparable secular activity treated more favorably than religion, strict scrutiny. So I highlight the any, but the comparable is going to be the big challenge. What is comparable? That's what's going to be important for crafting future rules. That might be this fall. That might be further along. I hate to think the winter, the spring, who knows how long. Turned into a bit of a downer now. That's the chuckle that I was looking for. All right. But what matters here is this is going to be hard. You go too broad and the court says, you haven't been nuanced, you're not using your expertise. You go too narrow, well, now you're discriminating against religion. This is going to be a very, very thin line, very hard road for public policy makers. If I had answers, I would tell you. I don't. I can only tell you that's going to be really, really difficult. So changing gears a little bit here, Medicaid. I have a couple of cases here involving Medicaid. They both sort of peter out because we had a change in administration. These looked like big cases, turned out not so much. First is about the public charge rule, which refers to the US law that says immigration officials can deny a visa or permanent residency to a person who's likely to become a public charge. That means someone who is likely to rely primarily on government assistance programs. Specifically, that usually is calculated as you're receiving a benefit for 12 months out of a 36-month period. Historically, for 20 plus years, we've had this agency guidance that said, what we mean by aid here is direct cash assistance. Your more traditional welfare type programs like SSI or TAMF, Temporary Assistance for Needy Families, we don't mean Medicaid. Then we get a new rule in 2019 under the Trump administration that says, actually, we do mean that. We mean any public benefit counts towards being a public charge, affects your eligibility for a visa or permanent residency. This was immediately challenged. In July of 2020, we had a district court in New York issued an injunction, said, we don't know if this is valid yet, but we do know you can't do it during a public health emergency in the middle of a global pandemic. So you can't do it now. Maybe when we're out of it, which in July 2020 probably didn't look like we'd still be talking about it in August 2021. Separately, a couple of months later, another federal court in Illinois said, we do think we're gonna look at this directly, and said, this is invalid. Specifically, you violated the APA, the Administrative Procedure Act, really, really dry sounding, really, really important act. Basically sets out the rules for rules. All agents, now that one wasn't a joke. This is legitimately what they do. This is, this is the big statute that says all those big federal agencies that you've, heard of, the FDA, HHS, CDC, I'm just giving the health law ones, everything else, EPA, FTC, everybody out there, all the alphabet soup, they all have to follow this. You have to go through notice and comment, or it has to meet an exemption for that. You have to have sufficient factual basis. It can't be arbitrary and capricious. There's a bunch of these rules. You have to do it the appropriate way every time you're going to make one of these changes. So the problem here, the Illinois District Court said, was changing that interpretation. This new interpretation isn't consistent with the definition in the statute. So we're not going to have a mini course in administrative law here about how that's done, but these agencies don't get to do whatever they want. They have to follow the law that Congress has set out for them. The way Congress defined public charge didn't fit with how the agency was defining it. That's what the federal court in Illinois said. It was working its way up to the Supreme Court, but then we had an election. We had a new administration. And under the Biden administration, the agency said, we're no longer going to apply or defend this rule. Therefore, the case is moot. There's no reason to come down on it. And the court is amenable to that because, again, they don't do advisory opinions. If you don't have an actual case or controversy, federal courts aren't interested. We get a similar thing on work requirements for Medicaid. Medicaid's a joint federal state program. We have federal rules, but states get to do some things differently if they get a waiver, if they get permission or approval from the federal government to do it. And one thing that they wanted to do, Indiana included, was adopt these work requirements. Say, if you are going to get Medicaid benefits, you need to be employed, be in employment training or school, or be actively seeking employment in order to get access. That's not in federal law, so the state needs approval to do it. Trump administration was happy to do so. They granted several of these. This was challenged again for violating the Administrative Procedure Act. This happens a lot. I will say, from an objective point of view, the Trump administration had a very, very bad record on the APA in court. They lost about 60 to 70% of the time. It's about twice as often as your average presidential administration. They had a lot of trouble with administrative law challenges. Separately, though, well, excuse me, not separate. The big problem under the APA here is a rule that says these rules can't be arbitrary and capricious. And here, the problem the courts in Arkansas and New Hampshire district courts set out, they said, well, you took into account self-sufficiency of the beneficiaries. You want to encourage them to work. You took into account, the public fisc. Is this going to cost the state extra money or not? But the one thing you didn't account for in explaining why you were adopting these work requirements and approving them was what it would do to insurance enrollment, which is the point of Medicaid, to enroll people in insurance. Therefore, you just made it up. It's arbitrary. That's what arbitrary and capricious means. You just came to a conclusion with no basis in the law. This would have been an interesting fight, ultimately, but it's also moot. New administration almost immediately began rescinding those waivers, saying all those requirements we said you could do, you can't do them. They were almost all on hold anyway, either from these courts or because of the pandemic. So ultimately, we don't get a resolution on that. I said I was going to talk about ERISA. I said I would be mercifully brief, and I will. I do say it's the law everyone loves to hate. I stand by that. It's the Employee Retirement Income Security Act. If you've never heard of it, my compliments to you. It is a really difficult, challenging law. The short version is it's a federal law regulating benefit plans, health insurance, pensions, so on and so forth. The goal is consistency. We want to have a broad federal overlay here so that states don't do everything differently, because we're worried that multi-state companies will then just not offer benefits. They just won't offer health insurance if they have to comply with 50 different sets of rules. So we did have a case on this, and I mentioned only because it's going to have an interesting impact. ERISA is one of the only statutes, I think, in recent history to get to the Supreme Court more frequently than the ACA. This is about the 20th case that has made it up to the Supreme Court on ERISA. Judges hate ERISA because it is a very, very complicated law, but it's a very important one. Here, the issue was Arkansas wanted to regulate pharmacy benefit managers, PBMs. These are intermediaries that go between the health insurance plan and a pharmacy. So they administer drug benefit programs for health insurance plans, pay and process the claims for prescription drugs. The issue in Arkansas was they were setting prices that were below pharmacies' wholesale acquisition costs, and they were driving them out of business, particularly rural pharmacies that were paying more to wholesalers. So Arkansas said, we're going to set a minimum here. You must reimburse pharmacies at least at the price they pay to wholesalers. This gets challenged as preempted by ERISA because Congress wanted to set one standard. If this is regulating health insurance, it's out. It's preempted by federal law. Federal law is supreme. It trumps state law. And ERISA explicitly says it preempts any state laws that relate to employee benefit plans. That has about 6 layers to it. We're not going to talk about them because I want you to still like me at the end of this, and we don't have 6 hours. Importantly, though, the court unanimously said this is not preempted. This doesn't actually regulate health benefits. This regulates a separate entity. It's important because of its result, which is you're going to see more states do this. You are going to see a lot of states enact these rules, probably other ones too, for PBMs. So that may impact how drug plans are administered in various states. We'll see what happens. Quick couple of cases to watch. The eviction moratorium from the CDC is going to be a big one. Early in the pandemic, Congress adopted a temporary eviction moratorium that ended. President Trump asked the CDC to step in, and they did. This one didn't change with the administration. The Biden administration continued it and then continued it again. This was challenged as exceeding CDC's authority. District court said it does. CDC doesn't actually have the authority to do this. While on appeal, CDC said, well, not only do we have the authority, we're going to do it for even longer. But they said, absent an unexpected change in the trajectory of the pandemic, this was a few months ago, we don't plan to extend it any further than that. We're just going to July. Supreme Court heard this challenge. They said, okay, 5-4, just barely, okay, this is all right for now. But within that 5, Justice Kavanaugh was squarely in the middle. And he said, I think this actually does exceed CDC's authority. But since you said you're going to end it in a few weeks, and that will allow more funds to be distributed, rental assistance and such, fine, go ahead. But don't do it any more than that. Well, what happened since then? As we know, cases went up, funds still haven't been distributed, so the CDC extended it again. So it's going to go back to the court. It's in the DC Circuit Court right now. Expect the Supreme Court to hear this soon. This is a major public health issue for folks that have been relying on this. We have a lot of people who have had trouble paying their rent during the pandemic for a lot of reasons. I have no idea what the court's going to do with it this time. Justice Kavanaugh is going to be the one to watch there in the middle. He thought this was beyond CDC's authority, but will he still think that in the current scenario? He very well might. One more case to watch here is Dobbs v. Jackson Women's Health Organization. This is going to be in the court's next term, but it's likely to be the most important abortion case that the court has heard in decades. This is about Mississippi's abortion ban the Gestational Age Act. It was drafted intentionally to be a direct challenge to Roe v. Wade and Planned Parenthood v. Casey, the two biggest Supreme Court precedents on abortion. The Supreme Court overruling one of its own cases happens, but it's very, very rare. Prior cases, the court has said states can regulate but not prohibit abortions prior to fetal viability. That's been the rule for decades now. State restrictions prior to viability are unconstitutional if they create an undue burden on a person seeking an abortion. That's not what this does. The 2018 Mississippi law is different. This is a complete prohibition on abortions after 15 weeks, which is much earlier than most other states. It is pre-viability, except for health emergencies or fetal anomalies. So this is meant to be a direct challenge to Roe v. Wade. The reason they have brought this case, very likely, is those changes in Supreme Court membership. They think they can win. They may well. Last couple of cases the court has heard on abortion, they struck down laws that were called trap laws, targeted restrictions on abortion providers. These were rules requiring providers to have admitting privileges at nearby hospitals. Those were struck down most recently in 2020, but that was when Justice Ginsburg was on the court. And it was 5-4. Justice Roberts in the majority, concurring in the judgment, but not the analysis, ended up being another one of those bad split confusing cases. And ultimately the courts below them a little confused on how to apply the law now. It's not entirely clear. This is a case to watch because the district court ruled in favor of the clinic that challenged the law, the only clinic in the state, and issued an injunction to prevent enforcement of the law. The Fifth Circuit affirmed, which means if the Supreme Court did nothing, the law would not go into effect. The fact that the court's going to hear it matters because it means that at least 4 justices, which is how many you need to get them to hear a case, have something they want to say here. Probably a new majority favoring some change to that legal framework, the Roe and Casey framework. The question is how much of a change? Again, you're going to need 5 justices to agree. Is this going to be clarification of this test, a new test, overruling Roe and Casey? Nobody knows yet. Nobody knows. But it's going to be a really important case. And this is coming in this next term. So just one last bit here, and then I'll take some questions. Vaccines, vaccines, vaccines. It's all we've been talking about, it seems, for the last several months. Mandates being the new legal question. So we've had a couple of different scenarios here. One of them is in hospitals. This one is pretty straightforward. Had 2 major federal court rulings on hospital vaccination requirements, one related to COVID, one related to flu. On COVID, we had this case out of Texas, Houston Methodist, dismissed, challenge dismissed. Court said, this is entirely fine. This does not violate federal law. Hospital policy said all employees have to be vaccinated against COVID-19. Court said this does not violate state or federal law or public policy. Ultimately, this affected very few people. This very large health system in Houston, 26,000 employees. Almost all of them had already complied, but about 120 did not and ended up getting fired. That's who brought the challenge. Similar, but for flu vaccine, challenged by a pregnant employee, fired for non-compliance with a vaccination requirement. Court said, had no claim under federal or state law, case dismissed. Both of these are very consistent with general legal precedent here, especially for healthcare settings. Hospitals, similar entities can require vaccination as long as they provide some limitations or alternatives. That might be a religious exemption, might be mandatory masking, something, a little bit of a detail will be necessary, but generally speaking, these are fine. Last bit, close to home, vaccine mandates in schools. Right here at IU. Clausen case, IU required COVID vaccination for all students unless they were enrolled in an exclusively online program or receiving an exemption. 8 students challenged it. What they had to do was either be vaccinated or if they get an exemption, comply with a masking, testing, and quarantine requirement. District court refused to issue an injunction, wouldn't put a stop to this requirement. Seventh Circuit also refused. And very recently, just last week, Justice Amy Coney Barrett refused to hear the relief petition, refused to advance it up to the Supreme Court. So this is for now done. But again, this didn't answer the questions. These are on the emergency injunctions, but they do kind of consider the merits. The answer here is this isn't a very good case. IU, district court said, can pursue reasonable policies in legitimate interest of public health, protect their students, their faculty, their staff. And there's a long history of legal authority for vaccination mandates, Jacobson and Zucht cases being the most important. And the students still had a choice, even if the alternatives are undesirable. They didn't want to comply. They could mask. They could take a semester off. They could go to a different school. They could decide to do something else. Those are unpleasant, undesirable alternatives, but they are alternatives. Part of why I think this ended up not going anywhere here is since this was initially filed, IU has added an ethical exemption as well to the religious exemption and a universal mask mandate. So there's not much to fight about left. If you can opt out because you simply don't like it, and everyone has to wear a mask, it's not going to be a constitutional violation of saying you either have to get this or get an exemption, and if you get an exemption, you have to mask. It's a bad case now. I think this is why Justice Barrett wouldn't hear it. So that is a rundown here. Lots more happening around the states, around the country, but this is at least what I think are the highlights. So we've got a few minutes left for questions. I think somebody in the room is gonna give me the ones from online. Put my mask back on. Oh, nope, over there, okay.
If you are watching online, the Q&A box is open. If you have any questions you would like to put in there. Does anybody here have a question?
Clear as mud then, okay.
Such a good job.
Either that or I just threw so much information at everyone that they're still processing. Yeah, don't give me the space. I can keep talking about this for a long time. I mean, you know, folks online can log off, but all of you in person, you're stuck.
Here we go. Okay. So we have, sorry, I just lost my voice. Huge thank you for your expertise and taking the time to make this so understandable.
You're welcome.
Somebody said, keep talking.
Thanks, Mom.
So
I assume.
I was not. I don't think so anyway. That, I saw that somebody, I saw you a couple last names that were similar, but what is an ethical exemption example?
Essentially anything that isn't a religious reason. It could be, I don't believe in vaccines, but not for religious reasons. That would be an ethical exemption. Most of the time they look really similar, but they don't have to be tied to a specific religious belief. There are a lot of those in states, like, you know, vaccination mandates are nothing new. We've had them in elementary and high schools and colleges for generations at this point. As long as we've had vaccines, we've had some mandates for vaccines. Several of them do have these ethical exemptions, mostly for folks who just don't like it. It's well, I'll save some judgment on it, but it's a bit of a problem.
So another question that came through, does the FDA approval have any impact on the vaccine mandate case?
On the case, probably not. There is some debate among legal scholars on whether you can mandate a vaccine that is on an EUA versus in a full FDA approval. Practically speaking, the FDA approval is coming, probably coming this month or next is my guess. That will make a lot of these decisions simpler. Secondarily, I think that the folks who say that the EUA doesn't matter have the better of the legal argument. What will matter practically speaking, is that full approval is going to trigger some mandates in some places. Several employers and schools have said, we will mandate this when it receives the approval. So it won't affect the case, but it's probably going to have a knock-on effect here. Now all the questions. Okay.
I know they're coming in. Okay, so decisions. So this person had missed the first part of your presentation, but this was not covered. Decisions about capacity. Who can get a ventilator in regards to medically frail and disabled patients? Is there anything are there any cases about that?
Plenty, but nothing up this high yet. Never know when one of them might come through. It really, those big triangles mask a lot of complexity. We have had cases on capacity that make it up to the Supreme Court. We could have one sometime, but I'm not aware of any that have gotten that high. A lot of them will end up under state law. So watch the state courts in whatever state you happen to be in and watching this.
Can you talk about cases addressing the legality of mask mandates?
Ooh. They haven't gone very far yet. We don't have a lot of good legal precedent. Part of what makes this complicated is that we can get a lot of lower courts having different opinions on these things, and until they get a little bit higher up that hierarchical chain, we don't really have good answers. General answer I will give, this is the one I give to students on this one. If you're wondering about the legality of a mandate that you wear masks, whether that's a business, whether that's a city, replace the word mask with pants. It's funny, but I do mean that. There are a lot of other things that we can require in the interest of public health and public safety. We can require you to wear shoes. We can require you to wear a shirt. We can require you to, I think, to wear a mask, at least when it's justified by the prevailing conditions. And certainly a private business can.
Okay, so I've got two different ones here. I think they might. All right, I'm going to read one word for word because I haven't had a chance to fully read through it yet. With regards to COVID vaccination requirements, are there states that have made this unconstitutional to discriminate against individuals of state colleges, especially if the vaccine has not have FDA approval? How will this approval repeal prior bills? Will the repeal be necessary, or how quickly will schools need to adjust once vaccines become FDA approved? And then she says, I hope this makes sense.
I think it does. So the state university case is so far, the IU case is the one that's gone the furthest. And the answer was, this is okay so far. Maybe it changes, maybe it doesn't. I think this is probably where we are. Again, vaccination mandates, particularly in healthcare centers and schools, have a really long history. The fact that this is a new vaccine changes some of it, but not all of it. The FDA approval will probably make it a little bit more assured, but I think that this is probably going to generally pass legal muster, as long as there are at least some exemptions available, certainly medical exemptions. That one is pretty ironclad. If you're not medically able to get a vaccination, you can't be forced to have one. Religious exemptions, common. Thinking about the COVID-19 cases, thinking about, Roman Catholic Diocese and some of those others, probably need to have that religious exemption in there, I would guess. Ethical exemptions, questionable. And FDA approval, I think, will practically change it, but legally, I don't think it's essential. Because the EUA is approval. It is emergency authorization. It is temporary. But the FDA did look at it, and the evidence base is functionally the same. It's just the time frame that is different.
Thank you so much, Professor Orenstein. If you had questions in the Q&A, I will make sure that we get to those, and we will get an answer for those. And we appreciate all of you joining us. I will have the link for our September 1st lecture up as soon as I can, as soon as we make some more decisions and hear final verdicts on in-person attendance. So thank you all for joining us today, and we will hope to see you soon.
Thank you all for having me.